trying to figure out ultimately what is.
It's still a mystery as to why it took them. Hey everyone, welcome to Primetime Crime. We unfortunately are not live tonight. I had something with my kids' school, so I'm very sorry. We'll be back live again next Wednesday night, but I'm Lauren Conlon, as you know, and Jarrett Ferrantino, as you also know. Hi, Jarrett.
Hey, Lauren. Hey, everyone. So although we're pre-recorded, we still have breaking and great and current news. So I think that that's worth noting too.
Yes. When I say breaking news, I mean this is breaking. Literally before I signed on, I was just able to get the order consolidating cases for the purpose of the preliminary hearing for the 5 suspects accused for the brutal murders and kidnappings of Veronica Butler and Jillian Kelly. So we discussed on a video last week what was released in a recent motion. We found out how the women died, and it was shocking. It was absolutely terrible. But I think now, Jarrett, and maybe you agree that this could be some good news, that things are actually progressing in this case and things are happening.
Well, so prior to this breaking, you and I were reviewing the respective filings of the 5 co-defendants. Mm-hmm. So right now, Cole was okay with a joint hearing. Tad said no. Tiffany said no. Cora said no. Paul said yes. Mm-hmm. So it was 2 versus 3. 2 wanted to have a joint hearing. 3 did not. As predicted, I'm getting tired of being right on this show, but as predicted, the judge ruled that for purposes of the preliminary hearing, they will be tried together at this level. Now, since we discussed this last, okay, I reviewed Tiffany's motion and Cora's motions. Both very well written. We agreed there wasn't case law directly on point in Oklahoma, mm-hmm. but both of them their lawyers have done a very good job of articulating why having the preliminary hearing together could be problematic, but it's very theoretical. They didn't say the magic words. They're saying by the way, they said on August 21st, we received 4 terabytes of information, discovery, okay, at this stage. That is a ton of discovery, okay? So they're saying at this point, it's not clear to us whether or not our defenses are going to be antagonistic. What does that mean? It's not clear to any of, Tiffany and Cora, for example, whether or not they're going to be pointing the finger at one another. Now, I call a little bullshit on that, okay? Mm-hmm. The defendants know what they're charged with. The defendants know what, if any, their respective roles were in this thing. So they're preparing their defense long before they get the discovery of the state. I mean, I love this. Like, they're acting like, we're in the dark until we get discovery. No, you have your clients. You know what they're telling you. You can prepare a defense. And if Cora or Tad are saying this whole thing was Tiffany's idea, we didn't have anything to do with it, it's her fault, you can pursue that defense long before you get the documentation. Now, I'm just saying you'll know at least at that point whether or not their defenses are going to be antagonistic. However, I don't totally disagree with what the defense attorneys are saying. They're saying, how can we strategically prepare a defense and attack the state's case on behalf of our client without having all of the information? My experience has been this. You don't have discovery typically before a preliminary hearing anyway. So
right.
That argument kind of fell flat. As expected, these hearings are going to be held together. Can I
stop you? I just want to go over a few things you said to make sure I'm understanding. Yeah. You said the defense was given 4 terabytes of discovery, which is a lot of discovery. There's a lot of stuff to go through. There's a lot of stuff to work with there. So you're saying, okay, they want to be tried separately for the preliminary hearing because they're not even sure what they're going to use as their defense, let alone everybody else, all of the other suspects. And
that's one argument.
That's one argument. And then, the state is saying, well, we've given you plenty. This is obviously not necessarily set in stone for the actual trial. We're just going to try this out, maybe see how it works type of thing, to see where the issues lie, maybe what works well, or am I off base?
Well, you're partially correct. So the state didn't say we've given you plenty. The defendants are saying, Tiffany's lawyers are saying, you gave us so much, we haven't even had the chance to go through it. We didn't get it till August 21st. We're not in a position to say whether or not our defenses are antagonistic. One of the major things both argued, though, was that the judge was going to be so overwhelmed with all this evidence that they can't parse out, this goes against Tad, this goes against Cora, this goes against Tiffany, which is kind of an insult to a judge to say you can't handle all this evidence. Either way, the same judge is going to hear all this evidence over the course of several weeks if they were separated anyway, and is going to have to say to themselves, well, I got to forget everything I heard about Tiffany and only consider it about Cora. Mechanically, that didn't play out for me. So these were the right arguments to make. They're just not strong arguments in response to not consolidating the preliminary hearing. So
okay,
I think
I'll pull this up if you don't mind, and you can go over it. This is literally very, very, very fresh here. Just got this. It's funny. I wish I was savvy enough to make this, I guess, bigger for you. I'm just zooming in on my own screen, but let me know if you
can. Well, here's what I see so far.
Go back to sorry. Okay, there you go.
Okay, that one we don't necessarily need. They denied the request to have a separate hearing, so we know that. Go to page 2. Yep. And then if you look at the bottom there, it says the court has not found any published cases which would prevent the consolidation for purposes of preliminary hearing. Huge part of the case. They and the defense attorneys acknowledge that much. So I think we're fine. And then I'd imagine the court goes on to just say, we believe a judge can parse out this evidence. We believe there is no prejudice to these defendants. We intend to follow the rules of evidence and not consider improperly any evidence from one against another as it's presented. So I could just kind of predict what this says. If you want to just go on to page 3.
Just tell me when to keep going.
How many pages is it?
Let me see. It's 6 pages.
Okay.
Nope, 7. 6 pages because the last page is just signatures. So I'm
going to charge you by the page here.
I gave you $1. Okay, everything that we say here, client privilege.
Okay, so what the judge is doing here is just taking apart and dismantling the arguments that the 3 defendants had made that we just discussed. One is guilt by association, the specter of guilt by association. What you, as a multiple defendant representative, you're saying, let's say a piece of evidence comes in against Tiffany. And this family court stuff, for example, let's say that comes in. And she had all the motive in the world. And these Twombly's don't have that motive, right? There's an argument to be made that there's a guilt by association. Here is Tiffany, who had all this motive. Here's the Twombly's that are associated with Tiffany. They then are implicated in that motive. The judge is saying, I can consider, or a judge can consider motive with regard to Tiffany and still keep an open mind with regard to the evidence that is directly related, admissible, and relevant to the Twombly's. That's what that says. So the judge is saying, I get your argument. It's not carrying the day for the preliminary hearing.
Okay. And didn't the judge already, or I guess this was not the judge, I'm sorry, the state had already said, we're going to ensure that we separate everything and all evidence and whatnot. So it's not guilt by association type of thing. I thought that the state relayed that pretty well in their last motion.
Well, the state could do that. The problem, and they could try to do it all they want. The problem of guilt by association, and this is an argument that'll be made down the road and ultimately the time for trial. It's like, look, anybody who's associated with Tiffany, anybody who was talking to her at this time, you're sitting next to her in the courtroom. We're just going to impugn all of the evidence on you anyway.
Yeah.
That's the fear. That's what they're arguing against. A judge typically is not going to be found to be likely to do this, likely to just assume Tiffany has motive. Paul Grice and the Twombleys and everybody else, and Tad Cullen is guilty because of that. So
Right.
again, I just didn't see that happening.
Okay, page 4. So, and Jarrett is actually reading as we go along, because you guys, I'm not kidding. I literally just got this before we started recording. So
it's just saying that every defendant will have the opportunity to impeach each witness as presented.
okay.
So there's some of what they argued was, will the co-defendants be able to cross-examine a witness that is used solely for one particular defendant? And the answer to that is, if you have relevant impeachment testimony for a piece of evidence, you're going to be given the chance to cross-examine those people.
Okay.
It's not going to be a procedural quagmire. That's what
that's standard. Normally everybody can cross-examine, right? I guess I'm confused why that's in there. Okay, got it.
It's in there because it's a response to an argument that one of the defendants made.
Okay.
Okay, so again, this is just going on to say that each of these defendants is aptly represented. The cases that they cited don't knock this case out of a preliminary hearing. Yeah, it's just taking issue with some of the language that was briefed in the motion for severance.
Okay.
Well, it's just legal analysis. But in any event, the court's just justifying what they did.
So it looks like it says the preliminary hearing in these cases shall begin on Tuesday, December 17th, 2024 at 9 a.m. It is so ordered. I love when they write that.
Well, before they say that, they say secure in the knowledge that the examining magistrate has been and will continue to be assisted in the proper performance of his duties by excellent lawyers and excellent lawyering. These cases are consolidated. Now, I don't know if he's talking about the magistrate's clerks or the lawyers that are before them. Either way, look, here's big picture here. Big picture. The arguments that the defendants have made to sever these trials, sever these preliminary hearings, have not carried the day. And the major arguments they've made are guilt by association, inability to sort out the evidence, unfair prejudice, all of those things. It's not enough to sever a preliminary hearing. There's going to be one preliminary hearing, as we predicted.
Yeah, and it's just, it's a bummer because I don't think cameras are allowed in courtrooms in Oklahoma. Jarrett, what are the odds? And I don't know how this works because I've never requested anything like this. But when somebody is, I guess, okay, let me rephrase this. When can you request a transcript? Is it after it's all over, or can you request it, day by day? How does that work?
You could typically request a transcript. The press can get daily transcripts.
Okay, so I could get a daily.
Yeah, you'd be able to get those. I would think. There's no reason, because it's a public proceeding. It's just not a proceeding that video can be taken inside. So you can attend it. The problem here is going to be logistics. How many defendants and how many lawyers you're going to have? It's going to be a crowded courtroom. So there will be folks ordering daily transcripts, I would imagine.
Yeah, I agree. And for this preliminary hearing, do you think that the confidential witness will have to take the stand in front of the magistrate?
It all depends. So they certainly can. That's really the decision that the state makes. That's a strategic decision. Do they want to subject that person to, number one, breach their confidence at this point and subject them to cross-examination? They may want to hold that person until trial. But if that person is so critical, then they would use them at this stage to show these 5 defendants what strength they have in their case. If that witness is strong, let's play it out. If I'm that witness's parent, for example, I may not want to have to put my child through something like that. Okay, so that may go a long way in getting maybe somebody to waive this hearing.
Well, then, Jarrett, knowing everything you know about this case, And I know exactly what you're saying. That's a tough one, the confidential witness, because we all know, and everybody knows at this point, we don't have to say their name. I don't even know their name. I just know they're a daughter of one of the suspects. And what would you do if you were prosecuting this case? Let's say not using CW. What would you do? Who would you put on the stand here?
Well, so it's unique in Pennsylvania
Yeah.
because some hearsay evidence can come in. So I would, if I wasn't going to use that person, I would find another way to get their statement in. And I believe that's the same rule in Oklahoma. So as long as the only evidence you have at this stage is not just hearsay, you can just find a way to get that evidence in. So without using that particular witness. So what I would do is I would use my law enforcement personnel as best I can, as early as I can. These tend to be obviously much more experienced witnesses that will build that wall of evidence that you have. How did law enforcement first learn about this case? Who reported it? What steps did you take in your investigation? What led you to these bodies? Who owned this property? Who was using this property? Who are these victims? What association did they have with this person? So get law enforcement to give you as much of that before you even get to the lay witnesses. Then I would take the lay witnesses and put them on for their particular purpose. And for example, Mr. B, who owns the property, if I was using him, I would put him on and say, who accesses your property? Who has a lease to use your property? Whose equipment did you see on your property? Who asked you to use some of your equipment? And just start building that wall against that particular defendant. So I would I try to put on a mini trial. I don't put weaker or less important witnesses on at this stage. I try to show the defendants and the world, hey, we're not messing around. You're in a lot of trouble. This is what's coming at trial, and you better work this case out. That's part of what I'm trying to do. I'm also trying to meet my burden and show the judge that we have enough. And these are the right people.
I also think that with what I've read, I mean, DNA, some of the suspects' DNA is literally found on the women and things like that. So maybe, Jarrett, and this is just me guessing, maybe they won't have to put that many witnesses on the stand that aren't law enforcement or, as you said, lay witnesses. Maybe that won't be necessary for this pretrial hearing because and I could be wrong, but it just seems like the DNA evidence is kind of overwhelming.
Well, it is. But again, the way you get that in, here's how I've done that too. I would have my law enforcement people say there were articles of clothing, for example, taken from the gravesite, right? Okay. Were those articles tested? Yes. DNA of our victims and these defendants were found in the gravesite. I would then, so here's how that could come in at that stage. You would probably, if you're going to be testifying to DNA, have to bring in an expert. You're going to have an objection to law enforcement people just saying that. So you would, but just bringing in a DNA person to say Paul Grice's DNA was found in the gravesite alone is not enough. It's not enough of the story because you have an admission from Paul Grice. You better get that in. That's got to come in. You already have statements that Paul puts himself involved in this conspiracy. You got to get that stuff in there. So again, with what we know so far, yes, you want to get the DNA evidence in. Yes, you want to get any statements of these defendants in, but they run into a complicated legal issue, and it's called Bruton. And Bruton was argued in, I believe it was Cora's brief. Bruton is an issue where, let's just say you have multiple defendants. One of them confesses. And in their confession, they say, let's say Tiffany confessed and she says, Cora did this and Tad did this. Under Bruton, you can use Tiffany's statement against Tiffany alone. If she's not on the stand. So the law enforcement person that took that statement, and this is a little confusing. I hope I'm explaining it clearly.
No, I'm following so far.
Okay. Well, you're a very sophisticated legal scholar, so I would hope you're following. But,
right.
So let's put it this way. If Tiffany confessed and she said, Paul did this, Cora did this, Tad did this, but she's not on the stand, and a person that took that statement is testifying about that statement, They could only testify about what Tiffany said she did.
Right.
And under Bruton, you would have to say another individual did this, another individual did that.
And that makes sense, because who wants to listen to one of the suspects talk about the other suspects, I guess, when I don't know. And I understand, because
that makes sense to you. It doesn't make sense to me.
No, it does, because I mean, okay, in some cases, right, you can just be guilty by association because you were there. In this case, I think it makes sense because we've seen everything. Not one person allegedly is innocent in all of this. Not one person just stood there and watched. I guess
that's true, Lauren. But what I'm saying is, under this presentation, you have to clean up her statement. You can't use Tiffany. You cannot use Tiffany's statement when she's not the witness against Tad, Cora, Paul. You just can't do it that way. It's only considered against her, which is part of the difficulty in presenting a multi-defendant case. Judges get this. It's awkward. It's a little cumbersome to present it this way, but under that Bruton case that they cite, which I've had defendants, co-defendants say, we killed this guy, me, and in the Solinsky case, Hugo Solinsky's co-defendant, Paul, implicated both he and Hugo in the killing. When we were presenting this at the preliminary hearing, Paul didn't testify. So it was one of the detectives. So he could only say Paul and another individual committed this act. And the judge could only consider those statements against Paul at that point. Well, that's how Bruton plays out.
Let me ask you this then, and then we can sort of move on from this. But I'm also trying to understand. So in some of the affidavits, the OSBI had said that there is allegedly a recording of Tiffany confessing. That right there, if you play that in the pretrial hearing, it's kind of like, I mean, I know that you need more, but wouldn't that be incredibly damning and a huge deal? And if, like what you just said, if she's talking in this confession tape and she's explaining who did what, you're saying that is, nobody should be listening to that.
That would have to be redacted.
Yes. Okay. But she can say what she did, and that can be taken into evidence and taken into account by the magistrate.
Right. And just so we're clear, and this is how you learn this stuff, but if Tiffany was on the stand, ultimately, she can name names, right? Mm-hmm. If she's not, and her statement is being presented by a member of law enforcement, it has to be cleaned up.
Yeah. I think that by December, we are going to see a lot more, Jarrett, of what exactly happened. I still feel like Cole and Cora, and this is speculation, I feel like they played a bigger role than just diverting the vehicles, only because we know the evidence of foul play and what Cole and Cora had in their possession with the stun guns, their own pistols, and again, all of the blood that was found. So I think that we're gonna find out a lot more, either December 17th or whatever that date was, or prior to that. And I mean, do you agree? Because the way they've released these filings, it's almost like they're letting us. I know they're not doing this on purpose, but they're being gentle with the public because this is so horrific. But I know that's not why. But it is interesting almost that it's little by little you find out how heinous these people allegedly are.
Well, and I've noticed this over the past several years that cases, you get this drip evidence that comes out in pretrial filings. Yeah. As concerned, I'm not going to say that prosecutors and defense attorneys aren't concerned about what information is public or how they appear in public or what the press is saying, but they're paramount concern really when they drop a filing or they're making an argument if a new fact is going to be pled out, which kind of leads us into Diddy. It's like the affidavit, so the charges themselves reference certain crimes, but the statement on keeping him in jail got into some additional details because at that time it was more relevant that facts were presented to equip the judge with enough information to make a decision. So
Right.
Here's how that typically plays out too. If you're fighting for a piece of evidence, for example, if the defense tries to suppress certain pieces of evidence, the state's response will be an articulation of how that particular piece of evidence fits into the crime itself. You cannot tell that story without getting into the gory details sometimes. So
Yeah.
I think information out of respect for the victims, out of an attempt to not appear too salacious, is held close to the vest and presented on a need-to-know basis. But as things, the need-to-know basis expands as the trial approaches and ultimately when the trial is on.
Yeah, and I do think that the DA maybe has been careful about this. He knows that, you know, it is a small community, and I'm sure he is trying to be a bit gentle with some of this, and I think that's good. So okay, so as I said, I will just let me get the date one more time. So the pretrial hearing is scheduled for Tuesday, December 17th at 9 a.m. Central. And it is so ordered. And I do not believe there's any other, let me see if they added any other dates before then. So far, there's no other events. Oh, wait.
There's going to be those discovery conferences.
Yes. So that is on Wednesday, October 16th at 9 a.m. That
and
is
they're going to be every other week, if you remember. Those are just on the issue of discovery.
So I don't think those are happening anymore because the next one, every month?
I'm sorry. Yeah. Every month.
Yeah. So every month. So yeah, the next one is Wednesday the 16th, and then it's probably November, and then. Yeah,
and sometimes now I've had cases where you have a pretty ambitious judge making sure everybody's on track. Sometimes it's enough to not actually appear for the hearing if there's a joint submission from both sides saying, "Hey, judge, things are on track. Our goal was to exchange this several thousand pages of information since our last hearing. This information has been provided and accepted by the defense, and that hearing wouldn't be necessary at that point." So the good thing is this judge is holding their feet to the fire. So.
And I lied. I have one more question about this. Sorry.
Yes.
I'm a liar. Okay. So would it be possible, depending how the pretrial hearing goes, that maybe Cora and Cole's team is like, hey, why don't we, I guess, petition to do our trial together?
So you're saying, is it possible for certain defendants to
like just two at a time? Or I mean, what if they go through this hearing and they realize that maybe the evidence against them isn't as damning as the other three or whatever? Could their legal team get together and be like, let's just do this together? I mean,
so that would be like a joint defense agreement. Ultimately, that's up to the court. So if there are two defendants whose positions align, whose roles are that similar, they make a joint defense agreement with one another and present that to the court. If I'm the DA, I'm not wanting to do this, and I've said this before 5 times. So if I have the opportunity to take 2 or 3 on simultaneously, I'll do that. But ultimately, it's up to the court. But it is possible. There are vehicles that, for example, a married couple, which we have in this case, if they wanted to have their case presented jointly, they could make that request, and their lawyers would make that request together. And it's motion for a joint trial between the co-conspirators, and they'll say they've essentially entered into what's called like a joint defense agreement, or that it's clear that their defenses are not antagonistic, that they are consistent with one another, and the court could hear them together in a manner in which makes sense, won't confuse the jury. And the DA, if all that bears out, the DA would say, fine. I mean, they may be willing to do that.
Yeah. I had this thought today, and I was like, God, imagine trying to schedule, let's say the state needs some of the same witnesses for all 5, scheduling a witness 5 different times. That's absurd. You can't, how do you have a fair trial, I guess, on either side doing it 5 times? It's so weird.
Just think of putting victims through that 5 times. Just think of tasking that DA's office with presenting this massive case 5 separate. It's just, and you'll hear that term, judicial economy. Judicial economy isn't just about money. It's about resources. It's like, hey, how could we tie up our victims teams like this? How could we tie up? And you may say, hey, fair enough. You had 5 people go bad and participate in this killing. And I'm not saying these DAs aren't willing to do this, but there are more judicially and justicious ways to do it. And more economic cost is one factor, but resources are another.
Yeah. Okay. Well, we'll keep an eye on this as we always do. It sounds like we'll have a little bit of a break until probably November, or perhaps the defense teams will start filing some motions that we can go over and explain. But for now, we will put that case aside, but justice for Jillian and Veronica as always. And we will move on to I am just giddy about this in a really bizarre way. But Diddy, he's in the slammer. He's at the Metropolitan Department of Corrections in Brooklyn.
As predicted, by the way, another thing we were right about.
Oh yeah, that he was getting arrested soon. Well,
so we predicted what his arguments were going to be, and the fact that it was likely the judge was going to hold him. And we even went as far to say it's likely P. Diddy will never know another day of freedom in his life. So,
I mean, he actually in an hour he has another bail hearing at 3:30, and then there's another hearing scheduled again in October. I mean, again, guys, if you are kind of just learning about Diddy and his arrest, Jarrett and I did a video yesterday. It's under our live videos, and we broke down the indictment. We broke down all the charges against him, which is sex trafficking, transportation for prostitution, and then a RICO charge. So this is really interesting. Diddy offered up $48 million in bail, and the judge is like, no, sorry, bye.
Well, this is what we've learned since then. So since our last video, you had him offer his home is totally paid off.
Do you want me to pull that up? His motion.
Yeah, so okay. It's $48 million. He paid off $18 million of that this year, knowing that he was going to be putting that up for collateral for any bail bond. And he offered to stay with his family. He subjected himself to electronic monitoring, all the things we talked about that the court could do. He cited his long ties to the community. He cited his charitable work. He cited the fact that he came back to New York to accept these charges, which
good job.
Yeah, congratulations. So all of those things kind of fell on deaf ears. I thought that the U.S. Attorney's Office did so I think, and Filio did a nice job, and Philos did a nice job of articulating what we expected. And that's the letter right there that he filed in support of Diddy being released on bail. However, the nature of these charges, the presumption is incarceration. The presumption is being held because of the nature of the charges. So their argument, Mark and Philo's argument, would have to overcome that presumption. It didn't get there. And the judge really took hook, line, and sinker everything that the U.S. Attorney's Office said. And I have that document here, and I'm going to just highlight. I mean, look, here's basically what it said. The things we talked about yesterday, the firearms being found, the access to an airplane, the nature of these charges are so severe. The fact that he tried to obstruct justice, bribe the security at the hotel, contacted witnesses since 2023. All of those things, but in making those arguments, they cite to a kidnapping in 2011 that he's alleged to facilitate at gunpoint. Diddy himself kidnapped another individual and forced them to participate in a robbery.
I am so curious about this. Like, do you have any idea?
The second was the car we talked about, the arson. Yeah. So that's in there. In addition to one of the things I missed yesterday,
the memo that you're talking about. Sorry,
this is
I just pulled up Diddy's bond. You saw that I pulled that up, but now you're reading from. Okay.
So a couple things from this document. Number one, they said they've interviewed not 50 witnesses, 50 victims. 50 victims.
I mean,
this is bad.
bad.
In the U.S. Attorney's Office, these are bright prosecutors. That's not a slip. That's not an error. It says the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the defendant's abuse. But the term, you're talking multiple victims here. Yes. They've secured 90 cell phones. 90. You could imagine one cell phone contains, how much information. So they're saying, but why that was cited is they're making an argument that the government has to show their hand a little bit here. They have to say the weight of the evidence we have is very strong. So in doing so, they're saying there's many witnesses and many recordings against you, P. Diddy. You're in big trouble. The other thing that I liked, two terms that they used in this document. Number one, they called the life and world around P. Diddy a culture of fear, which I thought was appropriate based on.
You're right.
I thought that really jumped off. That was at page 5, and
I'll go there. Oh, the firearms on page 4.
Yeah. So on page 5, under the drum magazine, if you see, they cite to what they call a culture of
on page 5. You said.
Yes. It says, in sum, the defendant's regular use of violence and threats of violence, as well as coercion against victims and others.
Oh, Jarrett, you froze. Sorry, you froze. Just go back. It fostered a culture of fear.
Yes, fostered a culture of fear. Wow. So,
yep.
There was another term.
God. Yeah, this is. I mean. This is.
It says that Diddy has
indictment, if not worse.
Yeah, it's worse because it's a lot of meat on the bones of the charges. It also says it's Diddy has. It talks about his dangerousness, and it says he has a disposition to violence, which, it's hard to accept. It's hard to accept. When someone is a celebrity or someone is. They're on the periphery of your life. P. Diddy's been around for decades. As the U.S. attorney said yesterday, this guy got the key to the city. He was accepted into our lives like so many celebrities that when they break bad or when they bad, you have to kind of reset how you revered them or how you, and not that I ever revered P. Diddy, but I certainly liked his music. I liked his style. I enjoyed the guy's success. But now this image of him is shattered. You have to accept the fact that this isn't someone who was just talented and a celebrity. He was someone that was alleged to be extremely violent, extreme. And this is a guy who you walk down the street. He's one of the most famous people in the country at one point. He's committing robberies. I mean, could you imagine?
No, it's terrible. And I did a couple videos yesterday on Diddy, and I'm really surprised at some of the comments. I mean, somebody had commented something like, since when is it illegal to be a freak? And I was just like, well, no, that's not illegal. It's illegal to force someone else to be a freak against their will, which is on record.
It's illegal to drug someone and force them to do it.
So it's illegal to force them across state lines to be a freak. It's illegal to shove narcotics down their throat to be a freak. It's illegal to drug their juices at clubs when they think the juices have no drugs in them and it's the vodka that they should watch out for. I mean, Diddy was smart. He knew exactly what he was doing, allegedly. And then, the last thing is that, it's also illegal to beat women. Domestic violence, that's illegal. So, I mean, it's just kind of incredible that also one of his attorneys went on Cuomo last night, essentially saying the same thing. Maybe his lifestyle is not exactly moral, but it's not illegal. And you're like, I'm sorry, what? I get it. That's your job. I completely get it. But I am very interested to see exactly who will be, I guess, testifying on his behalf, what evidence they're going to put forth. I guess maybe it might be about discrediting these witnesses. If I had to guess, I'm kind of going over it in my head now.
Well,
as
let me say, so the lawyers, so his lawyers, they need to be careful what they say, because in this detention memo, it actually cites the fact that Diddy and his lawyers were saying he'd never hurt a woman. This is all nonsense. Then the video came out of him punching Cassie. Then they said, yeah, so be careful. Like,
right,
you know,
right.
Defend your client. I get it. I respect that. Again, these are allegations. He has the presumption of innocence. I certainly can't sit here and say we know everything about this. Were there times I'm sure he's engaged in sexual conduct that was consensual? Sure. That's not what he's accused of.
Not exactly. Nobody is disputing that. But again, there is another hearing this afternoon. And unfortunately, we're not covering that, but I can put something in the episode notes just to note what happened. If anything of substance happened, but
there'll be no change here. There'll be no change.
I totally agree. It's way too serious, these charges. But I just want to point out exactly where he is right now, which is the Metropolitan Detention Center in Brooklyn, in Sunset Park, Brooklyn, which is really disgusting. It's been called inhumane. R. Kelly was there. Ghislaine was there. It's basically the federal Rikers, if you will. And it's so understaffed that an inmate was able to be stabbed 44 times before a guard could break this up. It's so bad. And Diddy is assumed to be in protective custody, or because there's still a lot of people in protective custody, it's been discussed that he actually might even be in solitary just to keep him completely safe.
Well, sometimes they're the same thing. It all depends on availability in the facility itself.
Yeah. In MDC, though, I don't think it is. I talked to a friend that has some connections there this morning, and he was telling me sort of the schedule that they have. He said they wake up at like 5:30 because breakfast is at 6 a.m. And if this is a normal schedule, you just let me know. I'm wondering, I don't know many prison schedules, but if you have a job, it starts at 8 a.m. and then lunch is at 11 a.m. and dinner is at 4:30 and then lights out are at 10 p.m.
Yeah, I would imagine. So it's a temporary holding facility for most of those individuals, and for Diddy. So, his first 2 days there, he's probably just sitting in his cell.
Right. Just stewing and being like, what is my life? I mean,
Well, he knew, but again, Lauren, he knew this was coming. Nothing could ever prepare you for that day, but he knew this was coming. I'm like, it didn't certainly come out of nowhere. He came back to New York to be arrested and charged.
What a good guy.
But I mean, to go from a $48 million one of your houses, to a cell, psychologically, I can't imagine what that does to a person who has to be in control, who runs his own criminal organization, who is said to be a billionaire, to now be confined to this small cell, to be told when you can move, when you can eat, when you can get up, when you go to, I cannot imagine psychologically what that does to a person, whether you're strong or not. That is and he's away from his family, and he's away from, these are that weigh on people after a while. So
and
it's going to be a long road for P. Diddy.
There were just old clips surfacing, and some of Diddy's boys were kind of like, Diddy once said he would rather eat lead than go to prison. Well, I don't know. Does anybody have some lead? Because it looks like that's probably where he's headed. So I thought that was interesting. And I think people are also a little confused. Where Diddy is not where Jeffrey Epstein unalived himself. There were just some questions, I think, in the press conference yesterday, if they had concerns about Diddy like they did with Epstein, which is totally fair. But Epstein was at the Lower Manhattan Metropolitan Correctional Center. That was MCC. And actually, Bernie Madoff was there as well. But I don't know if it's even open anymore. They might have shut it down after Epstein. I have to check and see. I'm not even sure. But yeah, they are two different places, two different shitholes, if you will. But all right. So Jarrett, that's all I got. I mean, I'm sad we weren't live today, but next week we'll be live again.
Well, and then we run Zone 7 today. If anybody gets a chance, check out our friend Cheryl McCollum hosts a great podcast, Zone 7. And Lauren and I, our episode dropped today. We're discussing Oklahoma. We're discussing Kansas moms, and we're discussing Karen Reed, which our listeners know I love to discuss, but we really we talk about these, talk about our show. So if anybody gets a chance, check Cheryl's show out. And she is actually the person that brought me to the Nancy Grace show and that allowed for me to meet Lauren. So Cheryl is responsible for Primetime Crime.
Cheryl's the best. Exactly. And Cheryl, you just love her. She's awesome. She's talented. She's fierce. And yeah, she's kind. So anyway, all right. We'll be back with some videos before next week. But as always, guys, thanks for watching and for listening.
Thanks, Lauren.
Happening. You're trying to figure out ultimately what is
It's still a mystery.